living trust versus the common law trust. In regard to status correction, I found that a living trust is better suited for titling the estate than any foreign or common law trust variant. I also want to caution you that this is my opinion, and I welcome anyone to enlighten me to the contrary. I'm pretty confident that this, however, is an overlooked key. Nonetheless, I don't see anything wrong with using a common law trust, and for that reason, when we prepare the status correction documents at thctrust.org, we give you the option to do either or. Now, here are some of the things I learned about the living trust that fit our objective precisely. Foremost, as all trusts, the property, title to the property, and the interest are held by the trustee. And this is something that we're doing to remove our estate out of the control of the default administrators. By titling it in trust, we have created a situation where lawfully and legally we can title the property in the hands of the trustee, and all governing agents and officials will support that. That's how the law works. We're changing the jurisdiction. So again, like with all trusts, the property, title to the property, and the interest are held by the trustee. The living trust, unlike other types of trusts, allows the testator, and the testator is the person who makes the will under the estate, and I'm using that term for a reason. But the living trust allows the testator, who is also the grantor or beneficiary, to also be the trustee. So yes, the living trust is the only trust that I'm aware of that allows you to act in the capacity as the grantor, the trustee, and the beneficiary. And by the way, a testator is a person who declares the will for an estate. And you have to remember that there's an estate that has been set up for everyone that was born. There's an administrative estate that had been set up. And the testator is the one who makes the will for that estate, although most of us die intestate. That means without a will, because we didn't know any better. But the point that I'm making, that when you deal with the living trust, the testator is also the grantor and the beneficiary, because this living trust technology is already acknowledged and accepted by states. And no matter what type of banking or commerce you're doing, if you're operating in the living trust, they know that the living trust uses the Social Security number. Right? So the Social Security number is actually the estate number. So you remember when you were born, the birth certificate thing happened, and then at some point they applied for this social insurance policy. All of this was a part of the setting up of your estate. So the identifying number for your estate is the actual Social Security number. So when they're proceeding against you in these courts of equity or admiralty courts, going after you for a forfeiture or a foreclosure, civil action, what they are always doing, aside from going after the trade name, they're actually going after the administrative estate with the banking functionality to create the proceeds and all that stuff. The trade name is only tied to that social insurance policy, right? So what I'm trying to get you to understand is that is the default estate that has been set up. However, when you create a living trust, and this is why I encourage you to get on YouTube and listen to what the public statutory attorneys say about the living trust, because you're going to understand that the living trust is pretty much the same as a living will. So this is going to allow you to address all of those probate matters. It's going to allow you to title and hold the property during the life of the grantor. Otherwise, that really can't be done. There's so many intricacies that will come into place, whether it's under the common law or whether it's under the commercial law or whether it's under the military policy, that will separate you from being able to title your estate during the lifetime. However, the living trust has met all those exceptions. That's kind of what I'm trying to point out and get to you. See, before we understood that the Social Security number was actually an estate number, and we always knew that it was an individual, it was not an individual. And what really cast the most light on this for me is once I began to operate in a living trust, I went to a certain brokerage and I opened up an account with them using the living trust. And of course they already knew that it was supposed to use the Social Security number, but when I got the paperwork back, the account said John Doe, trustee under agreement with John Doe. And I was like, wow. So for the first time, This is actually saying that there's a living man acting as the trustee administering a trust, which really is the title to an estate. So this is how this thing is all set up, and the focus and the effort is to change the jurisdiction and to give us a claim, title, proper claim and proper title to the property. Because remember, under the common law, under the ecclesiastical law, property can only be held in trust or by a man. Now, before we understood this information about the living trust, which is the first place in commerce that allows us to take the social security number and not be associated with it as a surety, but as a trustee, so that we can dictate the claims that's brought towards that policy to be discharged, offset, etc., etc. Right? Now, before we understood that, many people were using the common law express trust type deal, and it's for that reason that people were they would create an estate by applying for a new tax ID number with the IRS. Then they would create a foreign situs trust. I did the same thing, so I'm not saying they. And then we would try to link all of these different entities back to the social security number by using the SS4 forms, trying to create that triangle link from the estate to the trust back to the social so that we can title the property. Well, what I'm saying is that objective has already been accomplished in 1/5 of the amount of time by simply operating and creating the living trust. So that's just my perspective. And again, living trust always only uses the tax ID number. So separating people from their estate is the default policy of the probate code that asserts control over a minor in a decedent's estate. So once they charge your straw man to create securities and bonds and different types of proceeds through the default probate laws and the laws of intestacy and everything else, they can create those bonds, create those securities, proceeds off of your estate, and then they can assert control over those. And you will be blocked out of them because you don't have the proper standing. That's why we want to become the trustee with the title to all those securities that have already been created based off of that social insurance policy. We don't want to be the surety, we want to be the trustee. The property, as of right now, for the estate is being held under lock and key of probate during the life of the grantor beneficiary. And that is, again, the default, because they are presuming you to be dead by the information provided at the inception to the administrative estate provided by the mother. This is why government officers is needed to move property to and from the estate. This is when you get into the Form 90 and 91, and these are for government officers, right? Because they're looking at it as a government administering function to move property to and from the estate to pay foreign creditors, because there is no executor or no proper fiduciaries, no proper governing instrument set up for that estate to dictate how the business is supposed to be done. Right? So the living trust or the living will is the only trust from my research the only trust that was built with the functionality to navigate through the common law, the commercial law, the admiralty, the estate law, while holding the property outside of the control of the administrative estate during the life of the grantor, giving your trustee access to the property for whatever purpose the grantor may have, such as investing and borrowing against the property. A part of all of this status correction that is a very advanced topics, which is why I don't really talk about it so much in these videos. I'll talk about it privately in calls with other secured parties or members of thctrust.org, and when we get to the conference calls, I'll talk about it too. But part of what all of this is about is us being set up properly so that we can take these securities, these certificates of live births, and we can learn how to borrow against our own estates, essentially creating our own funding, creating our own money. Because instead of letting the entire commercial system bank off of you, you can bank on yourself, because you're the only one with the asset anyway, and that's the access of your credit. Anyway, that's what we're moving towards. I want to encourage you to join thctrust.org. You have the template for this living trust. If you're in the premium subscription group, go under the status matrix. You have this and other things. I also want to encourage you to look below this video and take that URL location, put that in your browser, and review that PDF. I encourage you to do so. Thank you.